A very good morning to one and all. In today's lecture of International Law, Chapter 3, we would be discussing about treaties, formation and ratification. So before we start, I would like to present some recap that we have studied in the previous videos, that is regarding treaties. Treaties, normally we have studied that there are three types: treaties, conventions and protocols. So what are these treaties? Treaties are the agreement between the states. Convention, they are a special type of treaties. And protocol, that is the amendments made to conventions. So treaties actually play a very important role because it creates an agreement it creates an agreement between the nation that they are to bind with, and these agreements and the treaty are being explained well defined in Vienna Convention on Law of Treaties. Normally it is called as VCLT, which was in the year 1980. So this is actually the basis that we will understand. From this we will understand about the treaties, the formation of treaties and the registration process, and basic definition that was being explained in treaties. So, Vienna Convention on Law of Treaties, commonly known as VCLT, was established, came into force in 1980. It was formed on Jan 27th, 1980. It consists of a preamble, 8 parts, which is divided. Then the entire treaty is divided into 8 parts and 85 articles. Now, when we try to understand these treaties, we need to understand about two concepts. So here the statement that I have given is that the non-sovereign states and vassal states can also be the part of the treaty. So it is very important that we need to understand what are non-sovereign states and what are vassal states. Non-sovereign states are those states, generally the term itself defines that non-sovereign means which is not a sovereign state, which does not have its own rights. Whereas vassal state is any state that is subordinate to another. First, second, the vassal state are these cases is the ruler rather than that of the state itself. Being a vassal most commonly implies providing military assistance to the dominant state when requested to do so. It sometimes implies paying tribute also, but a state which does so is better described as a tributary state. So vassal state are basically subordinate state which are controlled by the authoritative state. Okay, so and basically these are being provided certain military powers. So these are normally vassal states, and Vienna Convention on Law of Treaties includes non-sovereign states as well as the vassal states. Now, when we talk about the definition of treaty, Article 2 and Article 3 of the Vienna Convention have explained or given a brief idea about what treaties are, that we have discussed in the previous videos also. So, Article 2 of the Vienna Convention, it states that a treaty is an agreement whereby two or more states establish or seek to establish a relationship between them governed by international law. This is what Article 2 states. And Article 3 states that other subjects of international law can also conclude treaties. So these are the two major definitions that we come across when we try to understand what is treaty are. Okay, so now we will move on to the major aspects of treaties. As we have already studied about this, the concept of pacta sunt servanda, which means that the states are bound to fulfill in good faith the obligations assumed by them in good faith, right? So whenever a contract, a treaty has been entered, a agreement has been entered between two or more states, they are bound to be obligatory in nature, and this bond or obligation is in good faith. So, with respect to Pacta sunt servanda, Article 26 of VCLT states that every treaty in force is binding upon the parties and must be performed by them in good faith. Similarly, Article 27 states that no justification of failure to comply with the international law. So, treaties and pacta sunt servanda plays a very important role with respect to formation of a treaty. But there are certain cases where there are exceptions to the principal rule of pacta sunt servanda. So, what are these exceptions? Let us see. Exceptions to Pacta sunt servanda. First, new states as a result of revolt. So, whenever a new state emerges as a result of revolt, that we later in coming videos we will be discussing about de jure and de facto recognition of a state. Okay, so whenever a new state as a result of revolt comes, they are considered to be an exception to the principle of pacta sunt servanda, because a new state has been formed. So the previous agreement or the treaties that are been entered by the previously formed state are not being applied upon this new state. So it is a new state, thereby the new treaties are to be formed. So this is an exception. So whenever a particular state comes out and forms a new state out of a revolt, then the treaty which has been signed by the old state under which this particular new state is dominated or is under the rule or governance will be free from such pact treaties. Okay, so the second exception to the pacta sunt servanda is treaty obligations which are related to property which is seized or merged. Sometimes what happens is we often see that a part of a state actually it seeds out, it breaks off, and with the time and evolution that particular island goes and merges with a particular state. In that cases also, when a new merger has come or whenever a part of a territory is been seized, then it is considered to be an exception to the case of pacta sunt servanda. The third one, which is generally been seen, that is inapplicability of the treaty due to the fundamental changes which are been given in Article 62, which is also called as clausula rebus sic stantibus. Okay, so this is a philosophy principle upon which it states that inapplicability of the treaty due to any fundamental changes, that treaty does not will not be considered to be under the governance of pacta sunt servanda. So it is an exception wherever there is a fundamental change. So wherever there is a fundamental change, there is no obligation upon the parties to continue upon the treaty. This is what a principle is given. So these are the general exceptions that we actually see in the formation of treaty, that is an exception to pacta sunt servanda. Now, coming up to the concept of how these treaties are formed. So it is generally, when we study that a treaty, it is an agreement and it has been signed between the parties, so it is done. But there is a procedure that has been applied when two nations come together in order to form an agreement which is termed in terms of a treaty. There are certain steps that are to be followed. What are these steps? First one is appointment of representation by contracting states. Okay, there must be a representation of members from each state who are interested to enter into a contract. Second, what happens? Negotiation and adoption. All the negotiations and adoption should be done with 2/3 majority. So majority rule plays a very important role. It is 2/3 majority people should accept and should acknowledge to the treaty that are to be signed between the nations. Third, signature and ratification. Sometimes when the negotiation and adoption is being done with two-third majority, the parties which sign a treaty, they eventually become the part of the treaty. But in some nations, we also observe that the ratification towards that treaty is very important. Okay, ratification as in getting that treaty implementation in our country. For suppose when we see this in India, we follow this principle of ratifying the treaties that are being signed in an international platform. So whenever a treaty is being signed in an international platform, that treaty again is brought and presented in front of the parliament. It has been discussed, and then thereby it has been ratified within our ratified, so that we can bring implementation. So treaty comes into force in India only when it is ratified. Not simply signing a treaty does not make it binding upon the parties. India follows that there must be ratification of that treaty. Fourth, there must be assertion or adherence. Okay, and entry into force. Any agreement or any treaty, there must be an entry into force. So, what is the article that talks about ratification with respect to ratification in India? In India, Article 253 of the Constitution states that President on advice of the cabinet, has to sign and give consent only after it has been accepted by the parliament. Okay, so the ratification clause can be seen in the Indian Constitution under Article 253. Okay, so if you get a chance, just go through the Constitution, read Article 253 to get clarity upon how these ratifications takes place. The last one is registration and publication. Okay, so these are the major steps through which the treaties are being formed. Now let us go in detail with respect to ratification. Ratification, Article 2, Clause 1, Subclause B. It states that first, treaties are available from the date of its ratification. So, if a question has been asked that the enforcement of the treaty, from which date the enforcement of the treaty can be considered? So, it is the treaties are available from the date of its ratification. The day it has been ratified, from that day it has been considered that it came into force. They are prospective in nature. What do you mean by prospective? There are two terms, retrospective and prospective. Prospective means from the day the agreement or the treaty has been ratified, the application of that rule comes from that day. It does not affect those which are already been taken in the past. Retrospective effect means which are actually done in the past. Retro means past. Prospective means future. You have a prospective nature. So this ratifications generally are prospective in nature, which means that the day you sign these treaties and these treaties have been ratified in your country, it comes into force. The third one is, as I said, in India, Article 253, which talks about ratification, which is done by the President on the advice of the cabinet. Okay, so ratification is to be done. And the last one is, Security Council has the power to make sure that the treaties are ratified in order to maintain the international peace and security. What is the role of the Security Council? Security Council looks after that the international peace and security is being maintained. And if it finds that ratification of certain treaties are must and should, then it makes sure that those treaties which are being signed by the parties when during the conferences, those are enforced and ratified in their respective countries, so that they can maintain the international peace and security. There is a new term that we need to discuss here, that is pacta tertius nec nocent nec procent. Okay, so basically these are the Latin terms. So it is a bit tricky to rotate. It is a tongue twister type, but these are for a for a law student. These treaties actually play a very important role. Okay, so treaties actually try to emphasize these Latin terms. Actually, try to help us to explain it more positively and explain it in a more better manner. So the Latin term this, that is the pacta tertius nec nocent nec prosent. Try to spell again and again so that you get familiar to this. The meaning of this term is, this statement is, treaties neither obligate nor benefit the third party. So, what does it states that the treaties neither obligate nor benefit the third party. It is those people who sign the treaty fell into the obligation to follow that, and only those people are benefited out of that treaties. No third party or no person who has not signed this treaty will not be benefited out of it. So this is what pacta tertius nec nocent nec prosent says. But this Latin term also has certain exceptions. The first exception that we look on is Article 35, which says that in case of collateral agreements, even the third party is also benefited from it. Second, Article 38, the international customs. We have recognized that the international custom is one of the major sources of international law. So, international customs, it is like it is just cogent. It is just cogent in nature. So, it is an exception to this principle. The third is Article 36, which says that rights of the third state can be created in certain cases where it is required or where it is necessary that certain rights are to be given to the third states, the third party states, those which are not the part of the treaty, but still the rights can be extended to those parties also. So this is an exception upon which the parties which are not the part of a treaty can also exercise their power under Article 36, as they have the right to approach those treaties for benefits or any other obligations, though they are not the party to that treaty. And the last one is just cogence. Just cogence means certain principles that all states must observe, which are basically perimentary norms, perimentary norms. So these are the basic exceptions that you look on with respect to the Latin term, that is pacta tertius nec nocent nec prosent. Okay, so when there is a conflict, and this is also one of the important point, that when there is a conflict between a new norm and the old norm, the new norm will prevail and the old norm will become void according to Article 64. This is very true, right? When society keeps on changing and law keeps on changing, so the law which is being made, or the norms that are being created earlier, if we think that they are not so effective and then we make a new norm, obviously the old norm gets void. It gets void, so it gets automatically conflict, so cancelled. So if there is a conflict between new norm and the old norm, it is understood that the new norm will prevail and the old norm will become void. So the takeaways from the video are, regarding the law, we have discussed what law of treaties are. We have discussed what Vienna Convention on Law of Treaties talk about, and then we have also discussed about a Latin term, that is pacta sunt servanda. We have discussed about the exceptions with respect to pacta sunt servanda. We have also discussed how treaties are formed. We have discussed how ratification procedure is being done. both all over the world and in India. We have also discussed about a Latin term pacta tertius nec nocent nec procent and the exceptions to this principle. And lastly, we also discussed about just cogents. Okay, so these are the takeaways from this video. If you like it, please do like, share, subscribe to and click the bell icon of KALAW, and please support us with respect to the efforts that are being made by the students. Thank you very much. Thank you for patiently listening, and please do provide any suggestions or any additional matter that I need to add to these videos so that I can make more videos in a productive manner. Thank you so much.